Welcome to my Business Laws channel. I'm very thankful to you for watching my channel. If you have not subscribed yet, do subscribe to my channel. Friends, in this video, I'm going to discuss business laws paper, which was asked in Delhi University in the past years. Friends, syllabus for BCom Honors semester first and BCom semester second is the same. And even, many other students, MCom students, BBA students, uh, uh, BBA students, MCom, LLB, CA, CS, they're also studying these acts. So these questions, this discussion of the paper will also help them. So first of all, I would like to make one clarification. You see in this question paper, in every question, after every question, friends, reference is given. Friends, I am author of 9 books and I've written business law book also. For business law book, this for BCom, this is the 7th edition, is the latest edition. And for BCom Honors, semester 1, 9th edition is the latest edition. And you see in this question, every question, after every question, within bracket, references are given. So these are the references from my book. Like the first question, what do you understand by capacity to contract? Discuss the position of a minor in a contract under Indian Contract Act 1872. So friends, in this reference is paras 4.2, 4.5. So this chapter has been discussed in my book, Business Laws book, in chapter number 4. So for the answer for this question, you will have to refer to paras 4.2 and 4.5. So do not get any confusion. Okay, do not get confused, friends. So all these chapters you will find in any book on business laws. So friends, I have given the clarification for the differences. So very first question is, what do you understand by capacity to contract? Discuss the position of a minor in a contract under ICA 1872. So friends, in the business laws paper, there are 5 questions. And there is internal choice. And maximum marks are 75 and the paper is of 3 hours. After so many years, 2 years, the students will be appearing for the physical examination. Even in the last examination, the examinations were conducted in the physical mode in 2022. That is in March, April 2022. So this was for second years and third years, but first year's exams were held in OBE mode. But let us hope that we are away from COVID now, and now in the coming years, the students will be having their physical exams, in the physical mode. So friends, in the physical mode for this business laws paper, there is internal choice. Question may have 2 parts or 3 parts, okay, and then and this choice question is also from the same chapter, from the same unit, okay. Weightage of each unit in the business laws paper in BCom Honors and BCom I have already given in my earlier videos. So there is first question is always from the first unit. And the first unit is ICA 1872. So now, friends, I would like to discuss all these questions. What do you understand by capacity to contract? Capacity to contract or competency of the parties to contract has been defined under section 11. Discuss the position of a minor in a contract under the Indian Contract Act 1872. Every minor person, every person of unsound mind, every person who has been disqualified under the law to which is contract, they are incompetent to contract. Position of minor. There are around 15 to 16 points which explain position of a minor. And Mori Bibi versus Dharmodas Ghosh is a very important landmark case law regarding minor. All agreements which are entered into with the minor are absolutely void ab initio and they are inoperative as against him. The rule of ratification is not applicable in case of minor. And then apart from this, many more points. Minor can always plead minor. Minor's liability in case of necessity. Minor's liability in case of tort. Minor as an agent. Minor as a partner. Okay, so there are a number of points. 16 points are there. So you will have to write all these 16 points, and the main points are the beginning points. That is 5, 6 points or up to 8 points are the main points. You should always write this case law, which is Muri Bibi versus Dharmodas Ghosh. Okay, friends. So do give examples in your answer. But if you do not write examples in the long questions, then you lose your marks. So create good impression upon the paper's evaluator and cover all the points along with the case laws or examples in your answer. Moving ahead, friends, B part is Sundar, a bachelor, gave money to Susmita, a married woman, to obtain a divorce from her husband. He agreed to marry her as soon as she obtained a divorce. Sushmita later refused to divorce her husband. Can Sundar recover his money? So, friends, this is from the chapter Legality of Object or Consideration. This practical problem, we may call it case law, is from chapter 6, which is with the title Legality of Object and Consideration. Illegal agreement has been defined in the very beginning. And the last point of illegal agreement is it should not have been regarded as immoral by the court. The term immoral means against good morals. No husband or no person can give the money to another lady to obtain divorce from her husband. In this case, Sundar has given the money to Susmita, who was a married woman, to obtain divorce from her husband. And she did not obtain divorce from her husband. Can Sundar recover his money? No, Sundar cannot recover his money because this agreement is against good morals. Friends, just writing the answer in positive or negative is not enough. First of all, I have also explained how to answer case studies in the assignments or examination. You can refer to my video and there is certain format which you have to follow. Moving ahead, friends, choice question is, when is communication of proposal, acceptance and revocation complete? Under what circumstances an offer lapses and becomes invalid? So this question has got two parts. Very first part of the question is, when is communication of proposal, acceptance and revocation complete? So proposal and acceptance, both terms are different. When is the communication of offer said to be completed? And when is the communication of acceptance said to be completed? Offer is said to be completed when the offer comes to the knowledge of the offer. Acceptance has got two aspects. Communication of acceptance as against the offerer, communication of acceptance as against the acceptor. Communication of acceptor as against the offerer is complete when the letter of communication is put into the course of transmission and it is not possible for the acceptor to withdraw the same. And communication of acceptance against the offeree is said to be completed when the letter of acceptance reaches the offerer. And revocation means to take back, to withdraw. Revocation can also be revoked. Offer can also be revoked. Offer or acceptance either could be revoked. Revocation means to take back or to withdraw. But revocation of offer is valid only if it is made, before offer is accepted. Once the offer has been accepted, then in that case, the revocation of offer will not be valid. And similarly, we can talk about revocation of acceptance. Once acceptance has reached the offerer, then the question of revocation of acceptance does not arise. So section 4 and 5, section 4 of the ICA 1872, it deals with communication of proposal, acceptance and revocation. Under what circumstances an offer lapses and becomes invalid? How does an offer come to an end? Which are the various cases when the offer is revoked? There are about 7 to 8 cases when the offer lapses or it becomes invalid or it is said to be revoked. When offer always lapses after time, the offeree has rejected the offer and the offer will come to an end. Offer also lapses by subsequent illegality. Okay, so offer also lapses by if the offer is not accepted in the offered or prescribed mode. Offer also lapses by destruction of subject matter. So like this, friends, there are 7 to 8 points when the offer will lapse. Moving ahead, friends, next is the case study, which is from the chapter minor. A minor borrowed rupees 10,000 from B. After attaining majority, A requested B for another loan of rupees 10,000 and B gave it to A. Now A gave a combined promissory note of rupees 20,000 to B and promised to prepay the whole amount. Will B succeed in recovering this amount? So friends, let me explain the law which is applicable here. A borrowed rupees 10,000. A borrowed rupees 10,000 from B person. Okay. And now here, friends, if A person borrows 10,000 rupees from money lender or from B person, and he has issued the promissory, and after it becomes major, does not pay this money, then money lender or B will not have any amount, any right to recover this amount from minor, because this transaction occurred during minority period. But if minor takes up any transaction during minority and he continues it after majority, as it happened in this case, he borrowed rupees 10,000 when he was a minor and he requested B for a further loan of 10,000 rupees. And then he gave joint promissory note of the joint amount, that was 20,000. Then of course, friends, B will succeed in getting this amount from A because he has continued with the transaction. Friends, so the answer will be positive, affirmative, that B will succeed, that money lender or B will succeed in recovering this amount from A person. So moving ahead, friends, the next question is question number 2. What is the difference between condition and warranty in a contract of sale? So condition and warranty. This is from the Sale of Goods Act. Now, what is a condition? Condition has been defined under section 12, subsection 2. Warranty has been defined under section 12, subsection 2. First point of distinction will be meaning. I told you in my earlier videos, you should always give the distinction in the tablet. 4 points of distinction. Meaning, okay, then after that, remedies in case of treatment. Significance of stipulation. These are the 4 points of distinction which you have to write in the tabular form. Okay, and then friends state the rights of buyer in case of short delivery and in excess quantity ordered or goods mixed with other goods. Now, friends, in chapter performance of contract of sale, that is from the Sale of Goods Act 1930. You know, this head point is there are certain rules pertaining to delivery of goods. They are given in that chapter, and one of the points is defective delivery of goods. Defective delivery of the goods may be of 3 types: short delivery, excess delivery, and mixed delivery. Short delivery is, friends, a buyer has ordered, say, 12 Acer computers. But he was not supplied 12 Acer computers. He was supplied only 10 Acer computers. And excess delivery, he ordered 10, but he was supplied 12. He ordered 10 Acer computers, but he was supplied 8 Acer computers and some different computers of different brands. So friends, each delivery is defective in this case. Each defective delivery, whether short, mixed, or excess, entitles the buyer to put an end to the order or to reject the goods. So in case of short, he may accept whatever he has got, and remaining he can ask for the supplier. In case of excess, he can accept whatever he has ordered, and excess he can inform the supplier to take back. Same right he has in case of mixed transfer. But he wants to reject, then he can reject, saying to the seller or supplier that delivery was defective. Moving ahead, friends, now the choice question is, define the term unpaid seller as per the Syllabus Act 1930. Explain the nature of right of lien and right of stoppage of goods in transit of an unpaid seller. Unpaid seller has been defined under section 45, subsection 1. There are 2 points. The seller who has not been paid or tendered full amount or part of the amount, or who has been given bill of exchange or any other negotiable instrument as a conditional payment, which is subsequently dishonored. This you have to write under the meaning of unpaid seller. Nature of lien, right of stoppage of goods in transit. The unpaid seller has rights against the goods and against the buyer. Rights against the goods in 2 cases: when the property in goods has passed, when the property in goods has not passed. When the property in goods has passed, 3 rights: right of lien, right of stoppage of goods in transit, and right of resale. Right of lien is the right to retain the goods. There are 5-6 points regarding this right of lien. Right of lien is possessory in nature. Right of lien can be exercised even if the part of the goods are in the possession of unpaid seller. Even if the decree order has been issued, even then the right of lien can be exercised. But right of lien cannot be exercised when the buyer has paid the price or when the possession is lost by the unpaid seller. When the possession is lost, the unpaid seller loses this right of lien. There starts the second right, which is known as the right of stoppage of goods in transit. That is, when the possession is with the middlemen, with the agent, with the railway authorities, shipping authorities, or air authorities, and then the seller has come to know that the buyer has become insolvent. Then the seller can exercise, unpaid seller can exercise the right of stoppage of goods in transit. And then, friends, regarding both, whether it is lien or right of stoppage of goods in transit, when can lien be exercised? When the lien will come to an end? And when can the stoppage of goods right be exercised? How can it be exercised? By taking back the possession of goods from the middleman, or just by informing or giving the notice to them that goods should not be delivered to the buyer at the point of destination or on the way, as the buyer has become insolvent. As the question is of 10 marks, so friends, all these headings you must cover. And when will the right of lien terminate, or the right of stoppage of goods in transit will come to an end? So all these points you have to cover in the answer for this question. Then next is B part of the question. Sheila purchased a bottle of hair dye from a chemist shop without bringing to the knowledge of the chemist that her skin is sensitive to the use of such hair dye. After using the hair dye, she got some allergy. Can Sheila recover damages from the chemist? Friends, this particular problem is from the point, implied condition as to quality or fitness. The goods which are bought by the buyer, should they be fit for the purpose or not? It depends. In this case, they will not be fit for the purpose. Because if any person is suffering from abnormal, the customer was having, Sheila was having sensitive skin. She should have brought to the knowledge of the chemist, and she did not. And here, after that, she got some allergy. Then, Sheila will not have the right to recover damages from the chemist. Because it was her mistake, why she did not bring this fact as to her sensitive skin to the knowledge of the chemist. She will not have any right to recover damages from the chemist. Now moving ahead, friends, next is differentiate between LLP and limited liability company. LLP and LLC. So friends, question is of 8 marks. So you can write points in the tabular, meaning membership, registration, okay, then dissolution or winding up, number of members or partners, and then perpetual succession. So there are many points you have to write in the tabular form. Question is of 8 marks, you can write 16 points. So each point will be of half. Okay, so do write, cover all the points, because business law paper is very secure. You will definitely get good marks provided you have written well. B part is state the process of conversion of traditional partnership firm into LLP. For this, you refer in my book, chapter number 23. Conversion, what is the meaning of conversion? First of all, you write this. When is the traditional partnership firm eligible to be converted into LLP? Then what are the various steps involved? There are 7 to 8 steps involved. Okay, all those steps you write along with the explanation and try to get full marks, 7 out of 7. Then what is the incorporation document? Explain the process of incorporation of limited liability partnership. Now this you will find in chapter 20 of my book. Otherwise, in every book, all the chapters have been covered. What is incorporation document? This idea is a very important document pertaining to the registration of LLP. There are various steps involved in the registration of LLP. We talk about name of the LLP, and then DPIN of the LL partners, designated partners, and then registered office, ID, number of documents which are to be registered online. Okay, so friends, all those steps, 6 to 7 steps, documents, all rules you will have to write in the process regarding registration. B is write short notes on whistleblower. Whistleblower you will find in chapter number 21, which is with the title Financial Disclosures of LL. Whistleblower. Who is whistleblower? Who blows a whistle? Regarding what? Against, illegal work, illegal act. It may be of 2 types. One is internal, other is external. Lot of protection has been given to the whistleblower or employee under the LLP Act under Section 31. Mainly there are 2 points. We'll have to write those 2 points. Meaning of whistleblower, types of whistleblower, okay, and then you have to cover 2 points regarding protection which has been provided to the whistleblower under Section 31 of the LLP Act 2008. Then tax assessment of LLPs. This you will find in chapter number 22, which is regarding the heading financial disclosure of LLP. Tax assessment, taxation treatment of LLP. 16 points are there. Must cover all 16 points. What is the rate of tax? Okay, how is the Profit and losses of the LLP tax. Are the tax in the hands of partners or in the hands of LLP? DDT, dividend distribution tax. Okay, so like this, there are 16 points. You must cover all these 16 points. When is LLP liable to pay tax? Which return is applicable to LLP? ITF 5 is applicable to LLP. So all 16 points you must write. You can also give the example regarding this rate of tax. What are the objects of IT Act 2000? To which documents it is not applicable? Objectives of IT Act, 8 points are there. We will have to write 8 points. And non-applicability of the IT Act, there are some documents to which IT Act is not applicable. For instance, IT Act is not applicable to negotiable instruments other than check. It is not applicable to bill. It is not applicable to trust. Okay, so like this, there are 6 points to which IT Act is not applicable. Documents, agreements to which IT Act is not applicable. You have to cover all these points in the answer for this question. Differentiate between digital signature and electronic signature. Again, the distinction, friends. Therefore, to chapter number 26 in my book, 5 points of distinction are there. Electronic signature was inserted by ITA. It includes digital signature. The digital signature does not include electronic signature. Meaning, then apart from this, which one is more secure? Which one can be tempered, modified? Okay, which is internationally recognized. 5 points of distinction you should write in the tabular form. Private key and public key. Again, distinction in the tabular form. Private key, nature, function, listed in the certificate. Which one is listed in the certificate? There is a public key which is listed in the certificate, but which is not private key is not listed in the digital signature certificate. How is CCA appointed? What are his functions? Very, very important question from examination point of view. CAs are unstable to CCA. And friends, CCAs are unstable to the central government. They are always appointed by the central government. If the central government wants, they can also appoint assistant controllers and deputy controllers. His functions have been provided under sections 18 to 25 of the IT Act 2000. 5 points are there. With sub points, you will have to write all these points in order to get good marks. Cover all the points, friends. Then discuss briefly the following. Tampering with computer source documents. This particular heading you will find in chapter number 30 as it is given in reference. So one of the offenses, tampering with computer source documents. Nobody has the right to tamper or modify the computer source document. If he does, then there is a penal provision for that. He may be asked to pay specified fine or he may be put in the jail. Then it depends. He has committed the offense for the first time or for the second time. So whatever are the provisions, friends, you must write these provisions. Cyber terrorism. It is not the individual task. Group is involved. Okay, so cyber terrorism, here the punishment is life imprisonment. Okay, so loss to the property of the country and people also. Cyber terrorism. Terror is created in the minds of the people belonging to the other country. Okay, group is involved. Connections are broken. Internet data is stolen. Okay, so server is made down. Okay, so friends, there is punishment, life imprisonment is the punishment which has been prescribed for cyber terrorism in the case of under the IT Act 2000. Then question number 5. What do you understand by subsequent enforceability? This question is from the special acts. Now, this question is from the first unit, that is discharge of a contract. This is chapter 8 in my book. What do you understand by subsequent impossibility? Subsequent impossibility is also known as supervening impossibility. What are the grounds for subsequent impossibility? There are 5 cases which have been covered by subsequent impossibility. That is, performer is given the excuse. And there are exceptions also, where the performance is not excused. Like outbreak of war, death or incapacity of the promise, failure of the objective. Okay, these are the cases to which the subsequent impossibility applies. And there are other cases to which subsequent impossibility is not applicable. Commercial impossibility, difficulty in performance. Objective, when it fails partially, not totally, then in that case, friends, subsequent impossibility doctrine will not apply. And now I will take up the next, moving ahead, which is designated partner identification number. This is the 8-digit number which is issued once during the lifetime of the designated partner. It identifies the designated partner. There are 2 types of partners in the LLP. One is a normal partner, second is the DPs. DPs are more responsible. They're always liable for the legal compliances. And there's a separate penal provision for the LLP and separate penal provision for DPs. So friends, on this is a very important document pertaining to the registration of LLP. What are wagering agreements? Differentiate between insurance and wagering agreements. Wagering agreement is what? Wagering agreement is the agreement to do or not to do something. It is dependent upon happening of the event. If event happens one way, one person will pay the money, otherwise person will get money. There are 5 points of distinction between insurance and wagering agreements. One is valid, other is not valid. Objectives are different. Wagering is not welfare for the public benefit. Insurance is, of course, always entered into for the benefit of the public. Then an LLP has freedom in adopting any name of its choice and nobody can object to its choice. No, friends, LLP has to follow some rules, some provisions pertaining to the name of LLP. So those names, certain restrictions have been imposed by the government. So if those restrictions are taken care of, then only registrar will approve the name of LLP. So the LLP doesn't have a choice in adopting its name. The registrar will have to give the approval whether LLP can go ahead with the name of. So friends, this is all about the discussion regarding this question paper, regarding all the questions. It is all about today's video lecture class. I hope you will like the content, and this discussion will be very, very useful for all the viewers. So friends, keep smiling and lead a healthy life. We will meet soon. Goodbye, friends.